Good morning, everybody. Welcome to the Building Industry Center here in Albany and another in our series of breakfast roundtables. My name is Gregory Spaun from the law firm of Welby, Brady & Greenblatt, and today we're going to be talking about construction payment tools, helping contractors and owners find their wallets. There are basically four tools we're going to be talking about. Each one has their own use, but by all means, keep in mind, these are not always mutually exclusive. Sometimes you can use 2, 3, or even all 4 of these tools. So, as always, if you have any questions in the room along the way, ask. If you are viewing this later, or if you have a question later on, you can email me, gspaun, G-S-P-A-U-N, at wbgllp.com. First thing we're going to talk about are mechanics liens. Well, a mechanics lien, how do you put one on a property? If we're talking about a private project, private piece of property, it attaches to the real property of the owner. It can be asserted by a general contractor, a subcontractor, a supplier, or a laborer of any degree. You're not limited to so many generations down the subcontracting chain. Anybody who's worked on the property. This also includes architects and engineers. They're not performing physical work, but they're performing planning work for the improvement of the property. It can be foreclosed, just like a mortgage. On the other hand, a public lien, a lien on a public project, attaches not to the property. You can never put a lien on, say, a police station, a public hospital. But what it does is it attaches to the funds that the owner is still holding for payment out on that contract. It can't be asserted by the general contractor because that's the direct contractual relationship, and because the government's always presumed to be able to pay its bills, even if ultimately some small municipalities have difficulty. That's the presumption that underlies the provision for public liens. Also, unlike the private project, with regard to the public project, it can only be asserted, the language is that by the subcontractor and his subcontractor. Older language, but it limits it to the first and second tier subcontractors or suppliers. You have a first tier subcontractor, your first tier supplier can also assert the lien. In either case, the earlier you file, the better. On a private lien, anything filed before your lien, any additional encumbrances come ahead. So if you file your lien and then there are subsequent mortgages or other encumbrances, your lien has priority over that. Also, it's more prevalent on a public project, but on a private project too, this does apply. The more the general contractor is paid out of the monies owing on the contract, the smaller your lien fund is. If ultimately the general contractor has been paid in full, your mechanics lien is unrecoverable. So you want to file earlier while there's more money still left to be paid on that contract. It's a derivative remedy. And again, the owner is only liable to pay the outstanding unpaid value of the labor and materials it agreed to pay to the general contractor. So, if you assert a mechanics lien, and this has happened in my practice a couple of times, file a mechanics lien, get a call, oh, by the way, we paid the general contractor everything. Well, I know what's coming, so rather than start the lawsuit anyway and go through a whole bunch of discovery just to find out what I can find out at the outset, what I do is I ask, okay, send me a copy of the contract, send me a copy of the payment requisitions and the payments. If everything matches up, that the general contractor's been paid, I'll tell my client that the lien is unrecoverable and there's no point in proceeding. Because again, payment to the general contractor is a complete defense. Because the countervailing consideration for you, a stranger to the owner, being able to file an encumbrance against the owner's property and ultimately a lawsuit against the owner, is that the owner can't be made to pay twice for the same work. And because of the derivative nature of the remedy, if the owner has provable back charges, that's a credit as against the monies owing to the general contractor. For instance, general contractor takes a $7.5 million job. You're a subcontractor on the project. $4 million in, the general contractor gets defaulted. Replacement contractor comes in for another $4 million. That $8 million subsumes the original 7.5. Ultimately, the subcontractors on that job will be left without a lien remedy because the back charges, again, exceed the amount owing and depletes the lien fund. Important consideration when you're dealing with a mechanics lien. Time limitations. In New York, it's 8 months from the final performance of substantive work or furnishing of materials. You can't go back for a little minor punch list. Hey, I adjusted a couple of wall plates. That's not going to count as your last substantive work. Your last substantive work is basically a little after substantial completion, but once you get to the tail end of the punch list, that's not going to count. So, and again, it doesn't get extended if you come back for punch list or warranty. So you got to keep that 8 months in mind. Once you are substantially complete, then you should start thinking, if you're owed money, lien. The exception is for single-family dwellings. That time is 4 months. The exception to the exception, of course, if you're building a tract of 12 single-family homes, by example, you could be building a small tract of 2 or 3, they are considered a tract commercial development, and they have the 8-month time limitation. Another exception is retainage. If you're a late completing sub, if you're an early completing sub, your retainage may not be due until the end of the job. You may be waiting for 2 years. By that time, your 8 months from your substantial completion is long gone. So there is a window that reopens. After the retainage is due, you have 90 days to file a lien for the retainage. If you're owed other substantive contract balance, change orders, and haven't filed a lien, that ship has still sailed, but your retainage, you have that 90-day additional window to file. Public liens, what's the timing there? There's a sharp contrast with public improvement liens. There, that can be filed at any time before the completion and acceptance of the project and up to 30 days after. So if you're the early completing sub, doesn't matter. As long as that job is still open and hasn't been accepted by the public owner, you can file your mechanics lien. The issue with the timing of the public improvement liens is if you're the late completing subcontractor or you're awaiting your retainage and just haven't liened for it, that you only have the 30 days, you might not know when the owner gives final acceptance and when that 30 days starts ticking. You can send a letter under the lien law requesting that the public owner advise you as to when that 30 days starts running, but there's no penalty if the public owner somehow neglects to do so. Sometimes things get lost in a big bureaucracy. The proper person may not find your request until the 30 days has come and gone. So by the time they respond, you're out of luck anyway. So diligence is the key here. And again, the contractor itself is also similarly under no obligation to notify its subs or suppliers of completion. So again, you want to be diligent. And importantly, if there's a specific methodology set forth in the contract for determining acceptance, that must be followed. So simply the fact that the work is complete, that may not mean that there's been acceptance. There's going to be closeout and other contractual requirements that have to be complied with. Similar to your private liens, the abandonment or termination of the contract is equivalent to acceptance. You're done at that point. You don't get the benefit of the completion contractor's period of acceptance. Once your general contractor or your upstream contractor has been terminated, then that's when your time to lien starts to run. The duration, it's the same as private improvement liens, which is 1 year initially. With regard to a commercial lien, the 8-month window, once you file it within that 8 months, you can extend it by filing a simple notice with the county clerk or the public owner, and you can get 1 more year. The exception is for a single-family dwelling. The lien can only be extended by court order, so you don't get the benefit of just filing by an extension by notice. Then what you have to do is you have to go to court. It's a quick special proceeding. Dear judge, here's my motion papers setting forth the date I filed the lien, that I'm within my rights to seek an extension. Please grant my extension. The court can grant you 3 of those. It can't grant you all 3 at once, but it can grant you 1, 2, and 3 in sequential years. Importantly, though, because you can't extend a private residence by notice, and the court in any circumstance can only grant you 3 years, the total is for 5 years worth of lienable time on a commercial job and only 4 years worth of lienable time on a single family home. Also importantly, the order has to be entered extending the lien prior to its expiration. So if you come to a lawyer after 11 and a half months and say, hey, I've got this lien, I've already extended it, I need it extended again, you are not going to get that order from any court within that 2-week time frame. You need to be cognizant of this 5 or 6 months before it expires. So just keep that in mind as well. Again, diligence is the key. So again, your total time, you can have 5 years of a lien time on a commercial job, 4 years for a single family home. It can also be extended by a lawsuit. That's the statute of limitations on a lien. You can, so long as the lien is active, you can file a foreclosure lawsuit. What you file with that lawsuit, it's called a notice of pendency, which is basically planting a red flag in the county clerk's office saying, hey, there is an issue, a dispute over this property, I'm owed money with regard to it. That's good for 3 years. Once you file that, you no longer have to file extensions of lien or seek extensions every year. Your notice of pendency is good for 3 years. If the lawsuit takes longer, your attorney is going to make a motion in the context of that lawsuit to extend the notice of pendency, citing court delays, dockets, etc., and judge, please give me my extension, which you get for another 3 years. Also, if you file a lien on a property and somebody else pulls the trigger, they lien the property as well, they filed the lawsuit, and they named you as a defendant in the lien foreclosure action, which is required because the lien law provides that you name everybody with an interest in the property. As a lienor, you have an interest in the property. So what you want to do in that case is get that document to your attorney, who's going to file an answer with counterclaims asserting your lien, and file your own notice of pendency out of a belt and suspenders approach in case there's an issue with the notice of pendency filed, or in case that lienor ends up settling out and withdrawing the notice of pendency, you don't want to be left without the protection of your lien. So that's also one way to extend it. Now, something that's come into unfortunate vogue is, in order to get somebody's attention, you put a really big number on the lien that's more than what you're owed. Willful exaggeration. It's a really bad idea. I can't recommend against this strongly enough. First, your lien is null and void. Second, you can't have any recovery on the contract. Your lien is not only null and void, your breach of contract claim is null and void. You lose the right to file a proper lien on the same claim. You're going to be also liable to the owner or the contractor against whom you exaggerated the lien for any discharge bond premiums they incurred to discharge the exaggerated lien, the interest on the money paid into court to discharge the lien, attorney's fees incurred by the contractor or owner to discharge the lien, and here's the kicker, the amount of the difference between what might be the valid claim and the exaggerated amount. So for instance, you have a $5,000 mechanics lien. It's not going to get anybody's attention. It's $5,000. I'm going to add a zero. I'm going to kick it up to $50,000. Okay, well, not only is your $5,000 lien void, but the difference between the 5 and the 50, $45,000, that's how much the owner or contractor can get from you in addition to these other costs. Again, you have something 10 times the order of magnitude of the lien, and now you're on the receiving end of that judgment. Importantly, a willful exaggeration claim can only be pursued in the context of a lien foreclosure action. So what some people do is they file the exaggerated lien. They have no intent of foreclosing. They're just looking to basically rattle your cage. But there are tools such as demanding that the other side, that the lienor foreclose the lien, And if they don't, because it's exaggerated, you can make a motion to dismiss the lien. Again, still a really bad idea. Now, again, we spoke briefly about priority issues relating to time of filing. Mechanics liens are subordinate to all prior encumbrances of record, mortgages, liens, building loans. Amongst the various mechanics liens, it's not a race to the county clerk. So if you're one subcontractor and you file a lien 2 weeks before another subcontractor, it's not a matter of my lien's first, so if you run out of money, it's your problem. They're divided by class. So the first class of lien with the highest priority are those filed by laborers. Yes, your employee, if you don't pay him or her and they've worked on a project, they can file a mechanics lien. Typically, the laborer lien comes forth in the form of when a union shows up and say, hey, the fringe benefits haven't been paid. Well, technically, that's a payment to or on behalf of a laborer. So those liens have first priority. Second are your lowest tier subcontractors and suppliers. Then are your your first tier subcontractors and suppliers. And then finally, the general contractor. Ultimately, it's based on who is most innocent in the grand scheme of things, and they figure the further you are down the chain, the more innocent you were as far as not getting paid, and therefore the priority is basically an inverted triangle. All liens within a class, for instance, if you have 3 unions filing liens, they're all equal. It's the next class below that will only receive if there's enough to pay the labor liens in full. And again, regardless of date filed. If, for instance, you run out of money in between class 2 and 3, the remainder of class 3 get a pro-rata recovery of what's left, and then class 4, your general contractor, goes without. So when a lien shows up on your job, what can you do? Or if you're a lienor, what tools do you have to be able to determine the nature and extent of the lien? Well, first you make a demand to the owner for the terms of the contract between the owner and the contractor. The response must include the terms of the contract and the amount due or to become due. This way you know what your lien fund is going to be. If the owner doesn't respond, then they can no longer rely on the partial payment defense. I've already paid the general contractor. Well, I don't know that because you didn't respond to my properly served demand, so now the lien fund just got expanded. So if you're an owner or upstream contractor, it's important to respond to these in time. You can similarly make a demand to the lienor, hey, give me a detail of your lien. You say you're owed $70,000. Do your math. Show me how you're entitled to that. It can be demanded by either an owner or a contractor against whom the lien's filed. It must set forth items in labor or material and the value thereof for which claims a lien and the terms of the contract. So and unless the job is complete, you have to, even if it's a lump sum project, you have to break down your response in terms of the value of the materials. So that may be more or less than what's in your contract. It's going to look like a time and materials statement. Again, even if the job was performed on some other basis, because that's the statutory language and what you're entitled to under the lien law. You can also, again, I referenced this briefly in the context of an exaggeration. Somebody slaps a lien on a property, okay? You're not able to bond it off, you can't deposit it off, but you want it gone. You want this thing to come to a head. You can file a demand to the lienor to bring an action to enforce the lien, start the foreclosure. If they don't do that within 30 days, you can then bring a special proceeding to discharge the lien. It's useful for situations where you don't think somebody has the gumption to go through with the lawsuit. It's basically, hey, I dare you, bring it on. So, and again, if there's no response, you can bring the special proceeding to discharge the lien. Now let's talk about some common contractual provisions related to mechanics liens. Contract can contain a provision to discharge a lien from a subcontractor within a time certain. For instance, if one of your subs files a lien, your contract provides that within 7 days you will discharge the lien of record, either by bond, by depositing with the clerk, or somehow getting it off the property. You can also provide for, and contracts almost invariably do, lien waivers in exchange for progress payments. Importantly, agreements to waive your right to file a lien before your lien claim accrues are no good. They're void as against public policy. So, look, as a negotiating tactic, you see a contract that says, I shall not file a lien on the job. You strike it out, and then you agree to bring it back in for something else you want stricken out, because that clause is unenforceable. However, once your claim accrues, you've performed the work, you can be asked for a waiver of that lien in exchange for payment. That's perfectly legal. Finally, agreements to subordinate, release, or satisfy all of the lien are permissible as long as they're made after the lien is filed. So if that's one of the contractual provisions that once the lien is filed, you will agree to subordinate to X, Y, or Z. You have to abide by the terms of your contract. That's the nickel version of mechanics liens. It's probably more like the dime version, but it is an important tool. And the second tool, the trust fund statutes, also found in the lien law at Article 3A. Now, in New York, when an owner or contractor of any tier receives money for work performed, that person is obligated to hold the money in trust to pay its downstream subcontractors, laborers, and suppliers. Importantly, this consists of the funds you've received in connection with the improvement and any right of action for any funds due. You haven't gotten paid, but you do have a potential claim, a lawsuit, as against your upstream contractor or the owner based on the failure to pay. That's also a trust asset. You don't have to file a lien to enjoy the status of trust fund beneficiary. All you have to do is work on the job. That there's no requirement to perfect the interest, as it were, such as when you file a mechanics lien in the county clerk's office. Once you work on the job, you are a trust fund beneficiary, and it's whether or not you have lien rights. Again, if you've been sitting on the amount due for some time and the 8 months has passed, you no longer have lien rights, even though at one point you did. You're still a trust fund beneficiary. And keep in mind, you don't need to file a lien, commence the lawsuit. It's automatic. So, because these are trust funds, the issue becomes diversion, which is the use of trust fund assets for non-trust purposes before the payment of all trust fund claims. That's a diversion, and any agent or trustee or other person who consents to the diversion, the application of trust funds for non-trust purposes, is not only civilly liable, but guilty of larceny. This is a crime in addition to a civil lawsuit. And the degree of larceny is purely dependent on the amount. And in New York, you look at Article 155 of the Penal Law, and that sets forth a conceitedly outdated scale of the difference between what constitutes petty larceny, a Class E felony, D felony, C felony. It doesn't take much because these are not inflation-adjusted numbers, to get up into the C or B felony range. There is an exception where there's a good faith dispute. Hey, I didn't divert trust funds. I don't owe the guy. So because there's no trust claim, I paid out something else. I paid my overhead. I took profit because everybody else had been paid, and I don't believe he's owed money. That's a good faith dispute. Ultimately, you could be civilly liable in a lawsuit between the subcontractor and the contractor and the person who consented to the payment of trust funds, but that is a defense to criminal liability. People who accept the payment of trust funds take the payment subject to the trust claims. So, for instance, if a contractor goes out and buys a boat with trust fund money, well, the shipyard just took that money, the diverted money, subject to the trust fund claims, and that person can be liable to the trust fund beneficiaries for conversion. Now that's a very attenuated lawsuit that you would be looking to prosecute, but ultimately if there's no money elsewhere and that's your only remedy, sometimes you got to go with what you have. Action to enforce a trust must be brought as a class action for the benefit of all trust fund beneficiaries. So you want to name in the lawsuit anybody that you know who also worked on the job, and John Doe's number 1 through 10 representing people that you don't know who also worked on the job. And it must be brought within 1 year after the completion of the improvement, or 1 year after final payment became due, whichever is less. It's an important deadline to keep in mind. Because of that, there are certain record-keeping requirements in the lien law. The books of account must show the allocation of income and expenses for each trust administered. Basically, you have to keep a ledger for every job. Most contractors do. You also have to, again, separate books and separate from your general books. Failure to keep these books is also presumptive evidence of diversion. Further, there must be a segregated bank account segregated from your general account. Now, as a practical matter, it can be one separate trust account that's separate from your general account. You don't have to open up separate accounts. However, in today's banking world, you can open up a master account and then designate separate portions of that account as client-based trusts. I would advise this, even though it's a little extra headache at the outset to set it up. But when you get a demand for a verified statement of trust, you can go show the records from the account of every dollar in and every dollar out based on the bank's records, and your records would match. That goes a long way in defending against one of these claims, provided the numbers, of course, work out. Your books must show the trust assets receivable, your accounts payable, who owes what money, what contract, and how much. Accounts payable, who you owe money to, and on what contract and how much you've got in, who paid in, where the money came from, and how much you've paid out, and to whom it was made and for what purpose, showing that it was a trust purpose. And transfers for a notice of lending. That's also a permissible permissible use of trust funds. Again, a building loan agreement, you have to pay the bank. That's going to be out of the monies that the owner would have, and that has to be included in the trustee's books. Trust fund beneficiaries can examine these records. Trust fund beneficiaries can demand a verified statement of the trust or an examination of the trustee's books. And you can do this once every 30 days. What I like to do is I like to demand the verified statement first, wait 30 days, serve a demand for an examination. In theory, the verified statement will be the roadmap to what the book should show. If they don't match up, somebody's got a problem. And again, it's your choice. You're not limited to one or the other. And again, here's my recommendation. Demand the verified statement first, the roadmap, and then look at the books later. And if the information is not satisfactory, you can petition the court for a better response. The beneficiary can also demand a statement from the trustees. You can, for instance, if you're an unpaid subcontractor, you can make the demand of both the general contractor, and the owner. So how do you comply to the demand? A trustee has only two choices, and either one must be done within 10 days. Comply, or as a practical matter, you make a phone call. Hey, can I get 3 weeks to respond? It's purely the demanding party's choice as to whether they give you the extra time. In theory, you do only have the 10 days. And you have to provide the information about the entire trust. If you're the drywall subcontractor, you are nevertheless entitled to know about the mechanical subs monies, the electrical subs, the plumbing subs, the steel guys money, everybody on the job, not just the drywall scope. You're also entitled to information about any delay claims, not just contract claims, or the trustee can petition the court to vacate the demand. trustee doesn't get a protective order. The demand either gets vacated or not, and the grounds for doing that are very limited. There's a defect in the request. It wasn't served properly in time, or the demanding party is a mere interloper. They've got nothing to do with the job. They had no connection to the project, and therefore no right to the information. Those are your only grounds. How much time you have to put into responding is entirely irrelevant. And upon a failure to comply, you can petition for the order directing compliance. Failure to comply with that order is contempt. Moreover, you also get a presumption that you have diverted trust funds. Third tool, the Prompt Payment Act. This is governed by Section 756 to 758 of the General Business Law. It applies to jobs worth more than $150,000. The dispute on a job can be any amount, so long as a job is worth more than $150,000. What you do is you submit your payment requisition. Dispute as to discrete items on this requisition must be lodged within 12 days of the submission of that payment rec. Dispute needs to be made in good faith and only as to discrete items. They can't just say, we're not paying you, your work's bad. They have to set forth what on that schedule of values was defective work and why they're not paying you for that portion of the requisition. Another defense is, there's unsatisfactory or disputed job progress, defective construction work, disputed work materials. If there's a bona fide dispute as to whether there's been a compliance with the contractual requirements, then it's a good dispute. Then you get the demanding party does not get the benefit of the Prompt Payment Act. Now you have a breach of contract claim that you're going to fight out in court. The Prompt Payment Act is for prompt payment of undisputed sums. Another ground only applicable to the owner is that the architect failed to certify the payment. So what happens when if there's no dispute lodged? Items that aren't been disputed in good faith must be paid within 30 days from the approval. Or if it's a deemed approval, if the actual approval is not provided within the 12-day window. Upstream contractors must flow down their funds within 7 days, except where that contractor has in turn grounds to withhold on its subcontractor. They must provide a specific notice of why they're withholding, and if the approval's not made within the 12 days, if the dispute's not lodged within the 12 days, it's deemed approved. Now, what happens when you have a bona fide Prompt Payment Act claim? You get interest at the rate of 1% a month. You can suspend your work. Before you do that, you have to advise the owner that, hey, I haven't received this undisputed payment, and you must provide 10 days written notice of your intent to suspend if the payment's not received. And this applies at all levels of the chain, owner to GC, GC to subs. You can remove your tools from the site when you suspend. The upstream does not get to use them. You do have to renegotiate your D and remobilization costs. That's not automatically provided for in statute. Importantly, and this isn't just a shameless plug for my services, always consult an attorney before you seek to suspend. You don't want to grasp defeat from the jaws of victory. Okay, so what else can you do under the Prompt Payment Act? You can demand an expedited arbitration. You must provide the owner with notice of, or your upstream contractor with notice of the violation of the Prompt Payment Act and offer to sit down to resolve, and it must be provided by a verifiable delivery service. If it's not resolved, you can file for an expedited arbitration with the American Arbitration Association. The statute says the American Arbitration Association, you can't use another service. So just be careful of that. Finally, fourth tool, payment bonds. Generally, a payment bond is basically a surety's guarantee for either the performance of the project, the completion of the project, or the payment owed on the project. For our purposes, we're going to be talking about the labor and materials payment bond. Again, performance and completion bonds, they protect the owner against the contractor's performance. The labor material payment bond is how you help somebody find their wallet, because that guarantees payment to subcontractors and suppliers. They also provide a benefit to the owner by providing unpaid subcontractors and suppliers with an alternative recovery vehicle to the mechanics lien. If there's a payment bond, however, that doesn't mean you can't file a mechanics lien. I'll do both. On the other hand, like I went into previously, the mechanics lien is a derivative tool. The payment bond is not. So if I'm bringing a mechanics lien foreclosure action, I have to prove that there is money left due and owing to the general contractor. For a payment bond, all I have to do is prove that my guy has not been paid for good work. It's used extensively in the area of public works contracts, but it's becoming more and more prevalent on larger private jobs. Federal public works bonds are governed by the Miller Act. State and local are governed by, in New York, it's State Finance Law 137, which is called the Little Miller Act. Other states also have Little Miller Acts. Now, a payment bond claim. The first step is to make the claim to the surety. It's typically in the name of an insurance company, although it's not an insurance product, and that's important to keep in mind. But you make your demand to the surety, which requires you know who the surety is, who wrote the bond. One of the reasons why you want to be diligent at the outset is to have a copy of the bond, because by the time you're not paid, you're going to ask the contractor, hey, who should I sue to get money from you? Good luck with that. So have it in your file at the outset of the job. State finance law also provides that the copy of the bond is available for public inspection. You just submit a request, certified mail, return receipt to the agency. Importantly, don't label it a FOIL request, because that goes to the bottom of a huge pile. Label it request for copy of payment bond. That triggers a separate deadline that's not under the public officers law for FOIL, that's under the state finance law, where they've got 10 days to provide you with a copy of that bond. Again, the theory being you need to know pretty quick who you make the claim against, and this way, in case your time deadlines are running, which they are, you can properly assert the claim. Now, the Miller Act requires a contractor submit an affidavit with its request stating it's performed work or supplied materials, that you're not just seeking to find out who's got what bond. You're not the interloper. What you do is you make the claim by sending a certified letter to the surety detailing the contract, your scope of work, that you performed your scope of work without fault or back charge, and that you haven't been paid. The surety will acknowledge it, request further information, because they always do. Send the requested information. They're going to request basically your entire job file. And the surety is going to then tender to the contractor who procured the bond, hey, why haven't you paid? If there's no valid reason, then that's an issue, and that we'll get into a little later. Where the contractor is working for a subcontractor, the bond principal, the contractor who furnished the bond may not know who the claimant is, or the fact that somebody's out there that hasn't been paid, or even that a portion of its scope of work has been subcontracted out. So in that case, both the Miller Act and the New York State Finance Law require, in addition, you put the surety on notice, you put the contractor, the principal of the bond on notice, the contractor supplier who placed the bond, stating, hey, I'm here, I haven't been paid, so why don't you help me get paid? The Miller Act, the notice has to be given within 90 days of your last labor or materials and sent to any place that the bond principal maintains an office in any verifiable method. State finance law, within 120 days of your last labor or materials, okay, a little benefit there, and must be sent registered mail. And that's the word in the statute, registered mail. Now, who knows the difference between registered and certified mail? Well, certified mail is the one that comes with the green card. It gets scanned when it gets delivered. In the olden days, you had to sign the back of the green card. Because of digital delivery now and the scan, you don't always have to do that. That's certified mail. Registered mail is similar, except that it is in the custody of a postal police officer from the time it leaves the originating post office until the time of delivery. So if you want to have a valid notice under the state finance law, the statute says registered, you do registered. Certified, close but no cigar. Okay, so you place your bond claim, your surety's not paying. You want your money. Now what? Well, Both the federal and the state statute provide that you can't sue on the bond until at least 90 days from your last work or materials on the project, basically the cooling off period. Once that passes, Miller Act, the federal statute, provides that you must bring the action within 1 year of the contractor's last labor materials, basically a 275-day window. State finance law, 1 year from the date of the project is completed and accepted by the owner. Again, you're going to have diligence in finding out when that is, but this is a lot longer than that 275-day window. These are minimums. The actual bond may be more liberal. If it is not, if it's more restrictive, these will be the governing deadlines. Under the state finance law, but not the Miller Act, if the surety's denial was without substantial basis in law or fact, a court can also award attorney's fees to the claimant. Similarly, if the claim was without substantial basis, the surety can be awarded its attorney's fees. Substantial basis in law or fact does not mean necessarily bad faith, although that's included. It can be an honest mistake, but you're wrong. You just owed the money, you didn't think you did, and you were wrong about it. You didn't have the basis to deny the claim. So, and the surety acted based on what its principal told it to do. So yes, it can be held liable for those fees under that circumstance. Let's talk about some private bonds. Again, they are more prevalent on larger projects. These aren't governed by statute. So the Miller Act, State Finance Law 137, they don't apply. It's governed by contract law. Well, here, your contract's the bond. What the bond says will control. It may or may not mirror the terms of a public works bond. The AIA, American Institute of Architects, for instance, has the A312. That's its form of bond. There's the payment and the performance bond. They typically go together. Typically, if you're procuring a performance bond, it will come with a payment bond. The protections do dovetail. If it's an AIA form, it's the same provisions. The AIA form is compliant with the Federal Miller Act, New York's Little Miller Act, or if it's a manuscript bond, basically not quite handwritten but custom language, it can be different. It's strictly construed against the drafter. So if there's something that's not clear, that's going to be construed against the surety. If, for instance, there are two conflicting deadlines that, it's like the old Bugs Bunny cartoon, he went that way, that's not going to work. You're going to get the benefit because you didn't write the contract, the surety did. Quite simply, read the bond. They can vary extensively, and that's going to control your rights. And again, get it at the outset of the project, because by the time you need it, you're not going to get it. And unlike in the municipal context where you can make a demand under the state finance law, again, that doesn't apply. So if you don't have a copy of the bond at the outset of the job and you can't get it when you need it, you're good luck in finding out who to sue. Again, there's no requirement that they give you a copy of the bond once the claim matures. So good luck at trying to get it. Tell them at the outset, hey, I just need it for the job file. While everybody's in that, go along to get along mode, you have a better chance of getting it. What you might want to do is, if you didn't get it at the outset, but you know that there are other subcontractors who aren't paid, at the next Subcontractors Association meeting, have a chat. Hey, you have a copy of this guy's bond? Yeah, I do. I'll get it to you tomorrow. Awesome. Again, people who aren't getting paid, they like to complain, as is their right. And they're not going to do the principle of the bond any favors. So, and again, importantly, I did mention at the outset, and I'll repeat it, these are not mutually exclusive. You can assert a mechanics lien. You can assert a trust fund diversion statute. You can seek your undisputed monies under the Prompt Payment Act, and you can file a bond claim all at once, provided that the circumstances are there. So with that, are there any questions? Well, if not, you can always email me if you're watching this later, gspaun, GSPAUN, @wbgllp.com. Thank you much.